To the Honorable Judges of the United States Court of Appeals for the Sixth Circuit, in the matter of In re Thomas, case number 25-5708. Before you now is Kenneth D'Angelo Delo Thomas, submitting his truth that the state of Tennessee has wrongly condemned him as an innocent man to suffer and die in prison.
I come before this honorable court as a man seeking justice, not sympathy. Although not as educated or trained in the law as the state's attorneys, I have the truth on my side. For more than 2 decades, I've lived under a conviction that was built on concealment, false testimony, and silence. The truth was buried, literally hidden in another case's file. And that truth shows I did not kill anyone. This reply supports my application under 28 U.S.C. section 2244 B2B. Newly discovered evidence wrongfully withheld by the state proves that critical witnesses lied and that the prosecution concealed facts which, if known, would have proven my innocence at trial.
Section 1. Introduction and Framing under 28 U.S.C. Section 2244B2B.
I am an innocent man who has spent almost 2.5 decades behind bars for a crime I did not commit. What began as a tragedy has become a constitutional disgrace, a prolonged miscarriage of justice that defies the very principles this nation claims to stand for. My continued incarceration is not simply a legal error. It is a moral failure and a violation of the most basic guarantees of due process and equal protection under the law. For over 2 decades, the state of Tennessee has been aware, or should have been aware, of the constitutional violations that destroyed my life. From my early 20s to my late 40s, I've watched time, hope, and opportunity vanish while the courts looked away. The 6th Amendment promises me a fair trial, and the 14th Amendment promises fairness and due process. Yet in my case, neither has been honored. Tennessee's courts, by repeatedly ignoring or misrepresenting clearly exculpatory evidence, have proven themselves ineffective to protect the rights of the petitioner as contemplated by Section 2244B2B2. The Constitution demands correction of this wrong. This motion is not about technicalities. It is about truth. And the truth, now fully exposed through suppressed and newly revealed evidence, shows not only that I was wrongfully convicted, but that the state of Tennessee deliberately hid what would have proven my innocence.
Section 2. Rebuttal of the state's due diligence argument.
The state accuses me of failing to exercise due diligence, a claim as dishonest as it is hollow. The record itself proves that the critical evidence was not discoverable earlier because the state itself concealed it in another case's files. What they call lack of diligence is in fact the product of deliberate suppression, the precise conduct condemned in Banks v. Drecke, 540 U.S. 668, 2004. The suppressed evidence does not involve one continuous interview, as the state pretends, but 2 entirely separate interviews for 2 unrelated cases, a fact the state has now distorted. Detectives Tim Mason and Kent McAllister themselves clarified.
Well, hold on. Let us talk just a minute. Let us do these one at a time.
They drew that distinction because these were separate sessions, not one continuous conversation. The ending of that first initial interview, the one deliberately buried, was never turned over to the defense of this case. That single act ensured that no defense attorney, no judge, and certainly no defendant could have ever discovered it through ordinary diligence. When Paul Talley, the state's star witness, was re-interviewed under the guise of another case, that second interview / transcript became the only version ever referenced by prosecutors, my defense, and the courts alike, because it was the only one ever disclosed. By burying the end of that first interview and disclosing only the second one, the state violated every principle of Brady and Banks. Banks made clear that defendants are not expected to scavenge for hints of undisclosed Brady material when the prosecution represents that all such material has been disclosed. Yet, that is exactly what Tennessee has forced me to do. Search for truth in the dark, long after the fact, long after my youth, long after justice should have been done. If this interview had been disclosed to my defense as the Constitution requires, it would have appeared in the case file at least once during the past 20 plus years. It never did. Only recently, through persistence, faith, and a stroke of providence, did the truth finally surface. That the witness who helped convict me, Paul Talley, told detectives in that undisclosed interview that I was not the killer. His statement was clear. I know who did it. I just don't know his name. That truth was buried, and my life was buried with it. The state now wants this court to pretend that concealment is diligence and that deception is procedure. But the facts and the law say otherwise. The deliberate hiding of exculpatory evidence by those sworn to uphold justice is the precise evil that Banks forbids and that Section 22, 44B 2B exists to remedy.
Section 3, Rebuttal of Brady and Giglio Violations.
The state of Tennessee's conduct in this case is the very embodiment of what Brady v. Maryland, Giglio versus United States, and Napu versus Illinois were meant to prevent: the deliberate suppression and distortion of material truth. For decades now, the state has operated under the lie that it turned over all discoverable evidence. That is false, and they know it. They violated Brady by withholding an interview that clearly exculpated me. They violated Giglio by standing behind testimony they knew was false. And they violated Napu by allowing that falsehood to stand uncorrected before the courts, juries, and the people of Tennessee. The state story has never stayed the same because it was built on a foundation of deceit. In their interviews and transcripts that were disclosed, the prosecution's witnesses repeatedly changed their accounts, bending their words to fit the state's theory of the day. Each new inconsistency, each new omission, each rephrased memory was another patch in a crumbling lie. But the most damaging evidence is what they chose to bury. In the undisclosed Paul Talley interview, which lay hidden in another case file for years, Talley made it plain. I know who did it. I just don't know his name. That statement alone destroys the state's theory because it proves I was not the shooter. The state now wants to erase that truth by pretending that this interview was irrelevant or already disclosed. That is pure fiction. The hidden interview / transcript was never once turned over to my defense. It never appeared in the discovery for my case. It never appeared in my trial record. It never appeared in my appeals. It was buried so deeply that even diligent counsel could not have known it existed. the very situation condemned by Banks v. Drecke, 540 U.S. 668, 2004. In Banks, the Supreme Court recognized that defendants should not be forced to scavenge for hints of undisclosed Brady material when the prosecution represents that all such material has been disclosed. Yet that is exactly what I've been forced to do. Dig through decades of decay and deception to uncover what should have been handed to me from day one. The state either disregards or maliciously overlooks the truth, and in doing so, it has turned justice into mockery. The onus is not on me or my trial attorney to prove that evidence was hidden. It is on the state of Tennessee to show that it disclosed all Brady material. They cannot because they did not. This is not a small mistake. It is not a clerical error or forgotten document. It is the conscious choice to bury a man alive beneath the lie. And what's worse, even after being caught, the state still refuses to come clean. Instead, they double down on deceit. Their new narrative pretends that disclosure in another case file somehow satisfies Brady. That argument is not just dishonest, it's offensive. Disclosure in an unrelated case, years before my case was ever charged, cannot possibly fulfill the duty to disclose exculpatory evidence in my case. The attorney who received the unrelated file was long deceased by the time I was indicted, and my defense counsel had no reason or right to search someone else's case file for Brady material relevant to hers and mine. By any reasonable measure, morally, ethically, or constitutionally, this was a Brady violation of the highest order. The state's claim that it met its constitutional duty by burying exculpatory evidence in a different case file is the legal equivalent of hiding the truth in a graveyard and then blaming the dead for not finding it. Because Paul Tallett's and in turn Tory Glenn's testimonies were the only direct evidence of my supposed guilt, the jury's assessment of their credibility was material and necessarily determinative. Had my defense had the undisclosed interview, I would have been able to undermine their credibilities and reveal their willingness to lie to save their own skin. Furthermore, it would have directly contradicted the prosecution's portrayal of me as the victim's killer. Hence, there's a strong likelihood that this would have affected the judgment of the jury, and I would have rightly received a not guilty verdict.
Section 4. Rebuttal on actual innocence.
This is where everything comes full circle, where truth, morality, and the Constitution all meet. Because the fact is this, I'm innocent. And the evidence that has finally come to light doesn't just suggest my innocence. It proves it beyond any fair-minded doubt. For over 2 decades, the state of Tennessee has relied on the false testimony of Tory Levell Glenn, a man who had every reason to lie and every incentive to save himself. Glenn wasn't just a bystander to this crime. He was involved. He cut a deal with the state that guaranteed he wouldn't serve a single day behind bars for a murder that his own family knows was committed by his brother. And in exchange for that freedom, he did the one thing desperate men often do when cornered. He lied. He lied to protect himself. He lied to protect his brother. And the state, fully aware of these motives, chose to build their case on his deception anyway, because the truth would have freed me and exposed their misconduct. Then there's the testimony of Paul and Fred Talley. Their statements are not ambiguous. They are exonerating. They clearly establish that I was not the shooter. Even the buried Paul Talley interview, hidden for more than 20 years, confirms this in plain language. I know who did it. I just don't know his name. That is not an uncertain statement. It's an exculpation that should have been heard by the jury. It says that someone else was the killer, not me. But the state's entire theory of this case depends on pretending that those words don't exist, or that they somehow mean something else. In one breath, the prosecution claims I was the shooter. In the next, they claim I might not have been, but was still involved. When the evidence doesn't fit their narrative, they twist the narrative to fit the evidence. But which is it today? Was I the shooter, the accomplice, or just the scapegoat? The state can't even keep its own story straight because the story itself is a lie built on lies. Every version of their theory collapses under the weight of the facts. 1. If Paul Talley's first interview, the hidden one, had been disclosed, this conviction could have never stood. 2. If Fred Talley had testified truthfully as he does today, the state would have had no pretension of corroboration of my involvement in the murder clear across town hours later. 3. If the jury had heard Tory Glenn's full motives and deals, his testimony would have been laughed out of the courtroom. And 4. If my defense had been armed with the truth that the real killer was Glenn's own brother, I would have walked free decades ago. Taken together, this new evidence meets and exceeds the clear and convincing standard required under Schlupp versus Delo, House v. Bell, and McQuiggan v. Perkins. These cases don't just recognize the possibility of innocence. They demand that courts act when new, reliable evidence shows a wrongful conviction. As the Supreme Court stated in Schlupp, the miscarriage of justice exception applies to protect the innocent from a fundamentally unjust incarceration. That is my case exactly. I am the living embodiment of what Schlupp was written for. A man condemned by deceit, still standing on truth. This is not about re-arguing guilt or innocence in the technical sense. It is about preventing a constitutional atrocity. It is about ending the imprisonment of a man the evidence now proves did not commit this crime.
If, for example, one of only 2 eyewitnesses to a crime had told the prosecutor that the defendant was definitely not its perpetrator, and if this statement was not disclosed to the defense, no court would hesitate to reverse a conviction resting on the testimony of the other eyewitness. U.S. versus Agurs.
No reasonable juror, having heard the suppressed Paul Talley interview, Fred Talley's now truthful testimony, and the truth about Tory Glenn's motives, could have found me guilty beyond a reasonable doubt. In fact, no honest juror could have found me guilty at all. After 24 years of wrongful imprisonment, I've lost nearly half my life to this lie. But what I have not lost is my belief that truth still matters, that justice, though delayed, must not be denied. That's the only reason I stand before you alive today, or I would have committed suicide decades ago. This court now has before it what no jury ever did: the truth. And with that truth comes a duty, a moral and constitutional obligation to act.
Section 5. Conclusion.
After nearly a quarter of a century in a cell for a crime I did not commit, I stand before this court not as a broken man, but as a living testament to both the failure and the promise of American justice. Everything I've laid out in this reply, the buried interview, the false testimonies, the prosecutorial deception, points to one unshakable truth. I'm innocent, and the state of Tennessee has known, or should have known, for decades. My case is not a close call. It's not a procedural dispute or a technical question of law. It is the clearest example of what happens when truth is buried, when courts turn away, and when the system values finality more than fairness. The Constitution was not written to uphold convictions. It was written to uphold justice. When the Supreme Court decided Banks v. Drecke, it warned of exactly this kind of injustice. A case where the state hides evidence and then blames the defendant for not finding it sooner. That's not law. That's fraud in the language of justice. When Brady v. Maryland, Giglio v. United States, and U.S. v. Aggers were decided, they stood for one basic moral truth, that no conviction can stand when built on deceit. Yet that's exactly what Tennessee continues to defend. The Sixth Circuit now faces a defining moment, not just for me, but for the integrity of this system itself. My wrongful conviction is not just a legal failure, it is a moral one. To allow it to stand would be to sanction injustice as a matter of policy, to declare that innocence is irrelevant if discovered too late. But the Constitution says otherwise. Truth has no expiration date. Justice delayed is not just denied, it is justice waiting to be redeemed. I've lost more than 2 decades of my life to this lie. My youth, my family, my dreams, all stolen under the false pretense of guilt. Yet still, I come before this court with nothing but the truth in my hands and faith in my heart. I believe this court has both the power and the duty to correct what Tennessee refused to. This is not merely a petition for leave to file again. It is a plea for this nation to live up to its word, to prove that the Constitution still matters, to prove that truth still matters, to prove that a man's innocence cannot be buried forever beneath the weight of another man's lies. I ask, not out of bitterness, but out of faith, that this court finally do what every previous one failed to do. See me, hear me, and free me. Because continued imprisonment in the face of proven innocence is not just unlawful, it is inhumane. And if this court stands for justice, if it still believes in the principles carved into its own foundation, then it must grant this motion and allow my successive petition to proceed so that the truth, at long last, can have its day.
For those whom are interested in justice being done and helping to free Kenneth D'Angelo Delo Thomas from his prison cage, we implore you to share this video and petition the United States Court of Appeals for the Sixth Circuit in Cincinnati, Ohio. 540 Potter Stewart, U.S. Courthouse. Phone number 513564700. And the Attorney General for the state of Tennessee, Jonathan Skermetti, 500 Dr. Martin Luther King Boulevard, Nashville, Tennessee, phone number 615-741-3491. For the will of the people be done and free this innocent man.